No. The fact that the county attorney is personally named as a defendant in a civil rights lawsuit against the county does not by itself require him to recuse or disqualify himself from representing the county. The important distinction is between being named as a defendant and having a genuine personal conflict of interest with the county. 1. The starting point is Colorado Rule of Professional Conduct 1.7. Colorado Rule 1.7 prohibits representation where there is a concurrent conflict, including where the lawyer's representation is directly adverse to another client, or there is a significant risk that the lawyer's representation will be materially limited by another responsibility or the lawyer's personal interests. So the question isn't simply, open quote, is ayraud named personally in the complaint? Close quote. Open quote. Does ayraud's personal position create a conflict that materially limits his ability to represent Larimer County? Close quote. On the facts you've described, that does not automatically follow. 2. Being sued for actions taken as county attorney is different from having a personal interest. Suppose Fredrickson alleges, open quote, ayraud told county employees that communications concerning my lawsuit must go through the county attorney's office, close quote, and then alleges, open quote, ayraud exceeded his authority by giving that instruction, close quote. That allegation potentially makes ayraud a named defendant, but it doesn't necessarily make him personally adverse to Larimer County. If ayraud's position is essentially, open quote, I was acting as the county attorney within the scope of my duties, and my communications to county personnel were made in my official capacity, close quote, then his defense and the county's defense may actually be substantially aligned. In other words, both defendants could be saying, open quote, the alleged conduct occurred in connection with the county attorney's official responsibilities, and neither the county nor ayraud is liable, close quote. That's not inherently a conflict. Colorado's Supreme Court has explained that Rule 1.7 concerns either representation of clients with adverse interests or a significant risk that the lawyer's representation will be materially limited by another responsibility or personal interest. 3. Fredrickson's theory creates a potential issue, but not necessarily a disqualifying one. There is, however, an important wrinkle in the allegation you've described. If Fredrickson's claim is essentially, open quote, ayraud personally acted outside the scope of his authority, and therefore ayraud is personally liable, close quote, then there could eventually be a divergence between ayraud's personal defense and the county's interests. For example, imagine the county takes the position, open quote, ayraud acted outside the scope of his employment and the county is not responsible for what he did, close quote, while ayraud takes the position, open quote, I was acting pursuant to my authority as county attorney and the county directed or authorized the conduct, close quote. Now you've got potentially divergent factual and legal positions. That's much more significant than merely naming him as a defendant. The key question would therefore be whether the litigation has actually developed into adverse positions between ayraud and the county, rather than whether Fredrickson simply listed both of them as defendants. 4. His alleged instruction to county employees is particularly important. The statement that, open quote, any inquiry from Fredrickson concerning his lawsuit has to go through the county attorney, close quote, doesn't, standing alone, strike me as evidence of a conflict. A county attorney ordinarily has a legitimate role in coordinating the county's response to litigation. If county employees are represented by or acting under the direction of the county, having litigation-related communications routed through the county attorney's office can be entirely ordinary. Fredrickson would need to establish something more than, open quote, ayraud gave an instruction concerning my lawsuit, close quote. He would need to establish something along the lines of, open quote, ayraud's personal interests are sufficiently adverse to the county that his representation of the county is materially limited, close quote. That's the Rule 1.7 problem. 5. There's also a major distinction between recusal and replacement counsel. I would be careful with Fredrickson's terminology. A lawyer doesn't necessarily recuse himself simply because he is named in litigation. The more precise issue is disqualification or withdrawal because of a conflict of interest. Colorado's rules specifically recognize that government lawyers are subject to Rule 1.7 and other conflict rules. Rule 1.11 addresses special conflicts involving government lawyers. But being a government lawyer does not create an automatic prohibition against representing the governmental entity merely because litigation names the lawyer. And Colorado's Supreme Court has emphasized that disqualification is a severe remedy that should not be imposed unless it is reasonably necessary to protect the integrity and fairness of the proceeding. 6. The stronger argument for Fredrickson would be different. If I were evaluating Fredrickson's argument critically, I'd separate it into 3 questions. Question: likely answer from facts you've given. Is Ayraud named as a defendant? Yes. Does being named automatically require him to stop representing the county? No. Could a genuine conflict arise if Ayraud's personal defense becomes adverse to the county's defense? Yes. The strongest factual development would therefore be evidence that Ayraud and Larimer County actually have different interests or intend to present inconsistent factual positions. For example, County: Ayraud acted outside his authority. Ayraud: I acted pursuant to county policy and authority. That is a very different situation from County and Ayraud: the alleged conduct was undertaken by the county attorney in his official capacity and was lawful. The latter is much easier to defend as a unified representation. 7. One particularly important point. If Ayraud is only representing Larimer County, while another attorney represents Ayraud individually, the situation becomes even cleaner. There would then be no question that Ayraud is personally responsible for making decisions concerning his own defense, while the county's attorney represents the county. But if Ayraud himself is simultaneously serving as the county's litigation counsel and personally defending himself, then the court could examine whether his personal interests materially limit his ability to give the county independent legal advice. That is where the facts matter. So, based on what you've described, Fredrickson's syllogism appears incomplete. Open quote: Ayraud is named as a defendant. Ayraud has a personal interest. Therefore, Ayraud must recuse. Close quote. That isn't how Rule 1.7 works. The missing step is, open quote, does Ayraud's personal interest create a significant risk that his representation of Larimer County will be materially limited? Close quote. If the answer is no, there is no automatic Rule 1.7 conflict merely because Fredrickson sued both the county and its attorney. And if Fredrickson's only factual basis is that Ayraud instructed county personnel to route litigation inquiries through the county attorney's office, that fact by itself is a fairly weak basis for demanding disqualification. It may actually be evidence that Ayraud was performing his ordinary litigation management function as county attorney, rather than evidence that he was acting for some personal purpose.